This is the Situation Room, the only way to start your day.
Before we get into our conversation for this hour, tell us, Bomba.
I want to give you some other form of security. And the security we're talking about is energy security, where then Kenya Pipeline Company is here telling us that they are in the forefront in making sure that the economy continues to move forward, that you're able to go about your business every day, that manufacturing is a reality, that regional integration is a reality, because they are moving product that will be petroleum products from the port of Mombasa to the lakeside city of Kisumu and all the way to Uganda. And that right there is the integration that we talk about, that the two countries are able to work together to ensure that they are moving forward. But what exactly are they managing? They're managing over 1,700 kilometers of world-class, state-of-the-art automated system that then is able to assure you that you'll get quality product that is fast. They're able to secure it as well. So they're also investing back into the community through their CSR, where they're taking students, smart students, to school so that they're able to graduate, come back and plug back into the economy. So Kenya Pipeline is telling you, do you want to be part and parcel of us? Because remember, it is Kenya Pipeline PLC. Do you want to know more about it? Go to www.kpc.co.ke, because Kenya Pipeline, bomba letu, ukwaju wetu.
Kabisa, kabisa. The Law Society of Kenya's president is here with us this morning, and we're going to be looking at a number of issues. Charles Kanjama, good morning to you.
Good morning.
How are you doing?
Quite well.
Good, good.
Yes, I hope you're also well.
We are well. We are well. We are upright. So I guess that's a good place to start. And we'll see how we go through it. We're going to be talking about a number of issues this morning. And one may not be comfortable for a lot of people, but we're going to talk about it anyway, because maybe there's a problem. And so tell us where that's all starting from. Before we do that, however, Dennis has taken us to a very interesting country this week.
Yes. The country we're in is the fourth largest island in the world. So it is the home of vanilla. Why? Because when you talk about natural vanilla, they are the largest producers and exporters of the same. The country we are in is Madagascar. And you enjoy wildlife. The 90% of wildlife you'll find in Madagascar can only be found there. So if you are a fan of cartoons, there is one, I like to move it, King Julian, right? You can only find King Julian in Madagascar. But
that's the emperor penguin.
Emperor penguin.
Yeah,
yes.
You can only find it in Madagascar.
In Madagascar, yes. But the proverb, even a goat can bite when conditions become unbearable. Even a goat can bite when conditions become unbearable. How would you interpret it?
I think the assumption is that the domestic animals, goats being a good example, are peaceful and are not a threat to human beings. Some may even think that they are a bit cowardly. They have been tamed. But it's basically saying that everyone has a breaking point. It's like the other saying about a cornered cat. When somebody becomes completely cornered or completely strained, sometimes they can erupt in ways that are surprising. And this is a very good saying when we consider situations, say, of leadership, when leaders are dealing with their people. Sometimes they may think that the people are just docile and tolerant and passive and unable to react, and they keep adding to the burdens of the people. But a moment comes when that person or those people eventually react. Even in friendships, in relationships, in workplaces, etc., we need to always know that everyone has their red line.
Indeed.
Everyone has their moment beyond which they cannot cope or take it anymore. And to respect the boundaries of others.
Well said, well interpreted.
Absolutely.
Yeah.
So allow me to give a little bit of background to this conversation that we're going to have. And in what was reported as news, courts all over the country will be grounded on Wednesday, tomorrow, after the Law Society of Kenya announced a countrywide boycott in an escalation of the standoff between lawyers and the judiciary. On one hand, the LSK's counsel cited persistent graft and misconduct in the judiciary, while on the other, separate sources within the Judicial Service Commission, the judiciary, and the Kenya Magistrates and Judges Association accused the society of calling the kettle black. In this case, the society is the pot. And withholding crucial information on the grievances they raise. Now, if I go just a little bit further, the LSK says that there's severe case backlogs, judicial corruption, e-filing failures, and you've announced this boycott, while the judiciary insists all courts will remain open and operational. The judiciary spokesperson, Paul Ndemo, declared that all courts will remain fully open to protect litigants, resolving a record and as they had done in the previous years. Okay, Mr. President, somebody's got to be in their bonnet. What's going on?
I think Kenyans are aware of the various challenges with the judiciary. We are not disclosing to Kenyans what they don't know. They're aware of it. And the Law Society of Kenya is the foremost partner in engaging the judiciary to deal with these issues. So we use a lot of boardroom engagements, including court users committees and bar bench committees, to try and get reforms in the judiciary. And if you look at the statement that LSK issued last week on Friday, we've also issued another statement yesterday. We have emphasized that that process will continue. But LSK is frustrated. Lawyers are very frustrated that we keep receiving or getting the runaround, that we raise issues and the progress is inadequate. So there are some persistent problems in the judiciary that we need to highlight, and that this boycott is going to help us to highlight, because it is a form of industrial action. It is protected under Article 37 and Article 41 of the Constitution. It is a form of protest by lawyers. Litigants go to court and they seek the assistance of lawyers. So the reason lawyers are protesting is because they have found they are not able to assist their litigants because of some persistent problems in the judiciary. And the biggest monster that we are trying to tackle now is corruption. And there have been so many studies, even perception indices by people like Transparency International, a Kenya chapter, that have shown that the amount of corruption in the judiciary is beyond where it should be. Even EACC has done their own study. Even in meetings we've had with the judiciary leadership, they have acknowledged that there are challenges, and they've asked us to assist them in dealing with them. But one of the problems we find is when now lawyers or their clients, litigants, raise complaints with the institution that is meant to process those complaints, the Judicial Service Commission. Some judges rush to court to stop the Judicial Service Commission from doing its job. So it has reached a point where you have a parallel jurisprudence. Jurisprudence is the reasoning or thinking of the court. Any other case where people go to court, employees going to court to stop disciplinary processes of employers, state officers going to court to stop processes of, I don't know, the National Assembly or the Senate for impeachment, county assembly, and so on. The court says face the process, because there are institutional safeguards. If you are not satisfied with the institutional safeguards, you can then come to us on review or appeal. But that is jurisprudence touching everyone else. But now when it comes to some judges or judicial officers, they get indefinite injunctions that last for years on end, stopping them from facing accountability. So these are some of the things that are happening that the Law Society of Kenya is saying enough. The judiciary knows that every judge has to have the reputation of Caesar's wife, to be above suspicion. And that is what is expected by the oath of office and the judicial code of conduct for judges. So some of these things that are happening are the ones that are having a very deleterious effect on integrity and accountability. And I hasten to add, majority of the judges are doing well in difficult circumstances. So when we highlight the question of the boycott, we are highlighting it because some of the challenges are institutional. They don't relate to an individual judge, they're institutional. but they still need to be dealt with by the institution of the judiciary. So we are not by any case saying that majority of the judges or judicial officers have a problem. In fact, as LSK, we know that judges and judicial officers are lawyers, just like us. They're our colleagues. Some of them work very hard in difficult circumstances. They deliver justice for Kenyans who need the justice, and they need to be applauded. But we are saying that if there are any rotten apples, and rotten apples are everywhere, even in the Law Society of Kenya, we have rotten apples, and we have our own strategy in this council that I'm part of, the Law Society of Kenya Council, to also deal with challenges within the legal profession, to expedite the advocates' disciplinary processes. So as we are dealing with our own challenges, which are there, we are saying that we also need to deal with the challenges of the judiciary, because the judiciary are an arm of government. Actually, they're the last arm or organ of government Kenyans go to when everything else has failed. You know, they are meant to be the ones protecting the constitution. So if some elements within the structure of the judiciary then undermine constitutional protections, it becomes a big issue. Chapter 10 of the Constitution is on the judiciary, and it highlights two important qualities or principles of the judiciary for them to work effectively. One is the independence of the judiciary, and the second is accountability of the judiciary. The two go together. You can't have independent that is untrammeled or unrestrained by accountability. In fact, that is a false kind of independence. So LSK will always be there to fight and reaffirm the independence of the judiciary. To fight for and reaffirm the independence of the judiciary. We are always the first people to blow the whistle. But what we are saying is that independence is at the service of accountability. And if some judicial officers or judges undermine the very accountability structures that exist, like the Judicial Service Commission, and we are not then able to use court process to secure accountability, then we must use the other process, which is Article 37 and 41, the rights that lawyers have relating to protest and relating to industrial action.
Before getting here, Wakili, one asks the question, what are some of the moves that you've tried to access before? I know that you've mentioned about going to JSC, but does it mean that every other door when it comes to negotiation of just having a conversation around this, the judiciary, have fallen on deaf ears? Because by the time lawyers are downing tools, what that means is that those who have a court date, say today, are not able to get justice, you know. So what's the trade? Have you tried other maneuvers before that have not been adhered to, or what's the case?
That's a very good point. In fact, in our statement of Friday, we did recognize that lawyers are essential service providers. We are like doctors. We are among the people who during COVID were given leeway to travel from one place to the other. So when you're an essential service provider, it doesn't mean you cannot take industrial action. We've seen doctors going on strike. But it means they have to be limited or balanced, because you also need to think about the interests of the Kenyans you're serving. And that is why our general court boycott is for only 1 day. We could even have decided to do a full month. We said, let's do 1 day and see whether it will have an impact. Even sometimes we have public holidays that are very unexpected or unscheduled, like this National Tree Planting Day. And of course, we know there are some religious holidays that also are decided, they move with the calendar. And when that happens, the courts don't sit on that particular day. Cases get adjourned to another day. So we are saying a 1 day temporary inconvenience of litigants is important for the sake of the greater good. When people go to the streets marching or protesting, like LSK, we went to the streets 1.5 weeks ago, the traffic is inconvenienced. They have to slow down as you are walking along the road. But you even have police assistance. But Article 37 recognizes some measure of inconvenience for the public is okay, because it is part of exercising your freedom of assembly, your freedom of demonstration, petition, and picketing. You understand? So that is what LSK did. So we looked at the proportion. We said for one day, it's general court boycott. All courts, even for that one day, we've given a few limitations or exclusions, because there are people who have what we call interim orders. You have maybe an injunction or something, and it's coming to an end on that day. So you will need to attend court just to tell the court to extend the order and give you a new date. So we've actually considered those exceptions. It's like when you protest, there are still some people moving in the streets. You give them one lane on the side. They don't have the 3 lanes, but they have one lane to move in. So that's what we've done. Then we've also said we'll have an indefinite boycott of certain courts. We couldn't do an indefinite boycott of all courts. It would not even have made sense. But we identified a few judges and judicial officers who are enjoying court orders. They are currently sitting by virtue of court orders.
Okay.
So we've said for those specific courts, we are doing an indefinite boycott until such a time as those court orders are lifted, so that they can go through the accountability process.
The judges themselves.
Yes,
judges
exactly.
and or magistrates.
Exactly.
Okay.
And what happens is that we started discussing this issue as far back as 2 years ago in the LSK annual conference of 2024. We discussed it again in 2025. We've discussed it in several forums. We've raised it in our meetings with the judiciary leadership. But we've noticed some judges or magistrates are personally enjoying these orders, so they don't feel any motivation to advance their cases. And the experience is that those are some of the cases that then drag on. They delay much longer than any ordinary case.
How would a judge, I'm sorry to interject, how would a judge or magistrate benefit from a delay in a case? I can understand how maybe one side of a case where the complainant and or the defendant is enjoying a delay, how would a judge benefit?
When a judge is a litigant, they benefit like any other litigant.
Okay.
So you are invited by the Judicial Service Commission after
so
they
not
receive
presiding.
a complaint.
Okay.
JSC receive a complaint. When they receive a complaint, because it's their job to deal with complaints and even to investigate, sometimes they can do it on their own motion, what we call in law suo motu. On their own motion, they can investigate. Once they do that, they determine whether this particular matter has reached a level where we should ask the judge or magistrate to respond. So then they write to the judge or the magistrate and they say, please respond. Some of them, even instead of responding, they rush to court. They get an order to stop JSC from even asking them to respond. Can you imagine? So it's like you don't even want to go on record with what is your response to the allegation against you.
Didn't we see such a case with the Chief Justice herself?
Unfortunately, most of the judges of the Supreme Court are in the list of the courts we are going to target for the indefinite boycott, because they also last year were complaints were raised against them, and they each went to court individually. 6 of them, they got court orders to stop JSC from even getting their response to the complaint. No, we'll not even give our response for JSC to do its job. So you see, that is quite problematic. It's an approach in which the judge becomes like a god with a small g. They can't be questioned. You see, our constitution believes everyone must be accountable. They must respond. We are not telling them to respond on social media. We are not telling them to respond in any other forum. We are saying respond to that organ that has been put in place with your peers to process these responses. You know the composition of the Judicial Service Commission. It includes the Chief Justice. Of course, you'll not be able to sit if the matter is touching on her directly. A judge of the Supreme Court, a judge of the Court of Appeal, a judge of the High Court, a magistrate, 2 representatives of LSK, Attorney General, someone from Public Service Commission representing Public Service Commission, and then 2 members of the public appointed by the president or selected by the president. So the point is, Kenyans in 2010 came up with a structure of a Judicial Service Commission that is a body that has significant seniority and kind of like peers to be able to process complaints against judges, recognizing that there is need to balance between independence and accountability. That's what they are meant to do. So if some of the judges, a handful of them, are not ready to subject themselves to JSC, that becomes one of the diseases, cancer, that has been spreading, damaging the entire infrastructure of accountability in the judiciary.
I'd like to ask one question before we go to a break. And Wakili, we're talking about an arm of government which a lot of people in the recent past have referenced as maybe the one arm at this point that can actually be a source of hope. But what I hear you saying is that it's possible that they feel as though they're above the law.
Let me put it this way. As lawyers and as the Law Society of Kenya, we have a lot of confidence in the judiciary.
Okay.
And we believe very strongly that the judiciary is the last recourse for Kenyans. We cannot afford to have the judiciary disintegrate its integrity, its authority, its independence, and its accountability. It is precisely because we have so much hope and confidence in the judiciary that we are trying to get right these challenges that the judiciary is facing so that it continues to be fit for purpose. So let there be no doubt, we practice in the courts on a daily basis. And the reason we go to courts, the reason we advise our clients, litigants, to go to court is we believe that that is where they can get the ultimate remedy. But the judiciary, like any other institution, may have some weaknesses which need to be resolved. So the ones we are pointing out are the persistent and serious ones that we need to deal with very quickly, especially before we go to 2027 elections, because the judiciary needs to be at the level of the highest confidence and highest strength as we are approaching that very politically intense period. So we think this is the right time for the judiciary to put their house in order, to fully be consistent with the constitutional architecture. And of course, for us lawyers, we'll continue supporting the judiciary where they need to be supported and calling them out where they need to be called out, because that is how you build institutions.
Okay, let's take a quick break and then come back and talk about corruption within the judiciary, because it's a matter that has been raised by many a lawyer. It's one of the matters that's raised in these issues that you raise, and then, of course, feeding into that boycott for tomorrow. And it's also not a matter that can be solved in a day. So what are the steps towards making that being solved? The president of the Law Society of Kenya, Charles Kanjama, he's with us this morning, and we're looking at this impasse between the judiciary and the Law Society of Kenya and lawyers and practitioners of the law at large. There's a boycott tomorrow. We'll find out more about that when we come back. Stay with us.
Start your day.
At the First Avenue, which is the one that is quite widespread, it's like daily corruption, is in the court registries. The court registries are manned by judicial staff. And they're the ones who receive cases, filing of cases. They process court orders after they've been issued by the court. They issue summons. So like various other registries in this country where you have inefficiencies, lands registries, and various other registries, one of the ways that people deal with inefficiency is by having to facilitate the process. You use that term facilitation to refer to bribes or money that is being exchanged to get a service that you should have got as a member of the public. That's the most common kind of corruption in the judiciary. It's at the lowest level. It is smaller amounts, but it is happening very frequently. That one needs to be dealt with, and we have talked to the judiciary leadership about it. Sometimes they reshuffle staff. They ask us, please share the evidence. Challenge of collecting evidence, of course, in matters of corruption. But that is the first kind. The second kind is the corruption that affects the subordinate courts. These are the courts involving magistrates and sometimes in the tribunals. This one is the second in terms of frequency or commonality. The amounts involved are larger than the ones for the registry. In criminal cases, sometimes they may involve some judicial officers who receive some bribes so that they can reduce the amount of cash bail if it is during the time of plea, or so that they can give you bail if you have not been given bail before. In some cases, it is a notorious kind of corruption to influence a court outcome. And of course, a lot of this is difficult to get the evidence for it. But they are less frequent than registry corruption, but they are more common than corruption among judges. So the third kind of corruption is among judges of the superior courts. High Court, Court of Appeal, Supreme Court. Most judges are clean. Many magistrates are clean, I hasten to say. And the corruption that happens in superior courts is less frequent, but the amounts are larger when it happens. It can get to fairly large amounts. And this is what you found several of my colleagues in the legal profession abhorring and complaining about. All corruption involves somebody you know. So the corruption that is at the superior courts or the subordinate courts many times may involve maybe a clerk or registry official who's an intermediary, the judge. Sometimes it is somebody who's maybe a classmate of the judge or something. Sometimes even it's a lawyer who is the conduit of the corruption or influence peddling. What we are saying is that the judiciary should be a sacred temple or sanctuary where no corruption should be tolerated. And to the you could almost say, to the benefit of the Chief Justice, when we last met her as the leadership of LSK and we explained to her our concerns, she did say that she was committed to fighting this corruption. She said she wants the judiciary, every court station, to become a corruption-free zone.
How can that happen?
Yes.
If judges can come back to the courts and say that they would like to have, or rather, have an injunction placed or a stay whereby then they themselves cannot be questioned. How do you remove corruption from the judiciary if the alleged or accused agents of corruption can stop themselves from being questioned and or investigated?
That's a very good question. If I may use an analogy, when in first aid, they say you find a patient who may not be responsive, maybe is collapsed or something, they talk of the ABC of first aid. The A is airways.
Yes.
You look at the airways, you ensure the airways are clear. Maybe you check the posture of the person who's lying on the ground, supine or whatever form. The B is breathing. You try to focus on the breathing so that the patient can breathe. So you are trying to first clear the airways, restore breathing. Then the C is circulation. Sometimes that's when you start pumping the chest to restore circulation, blood circulation by the heart. So what we are trying to say is that in the judiciary also, to fight corruption, the first thing you need to do is to clear the airways. And this obstruction, in some cases by a few judges or judicial officers who obstruct GSC, is what is blocking the airways. So we want to clear the airways to restore breathing and ensure the circulation of the blood is unhindered to every cell of the body, in this case of the judiciary. So that is why we are having this targeted court boycott. It is precisely an emergency measure under the ABC first aid protocol, if I may use it as an analogy, to clear the airways, restore breathing, and restore circulation of the blood. Once we're able to do that, we think we'll be able to work effectively with the structures and the officers in the judiciary to fight the corruption that is within, and also to cut off those external people, some of whom are even my own members, who facilitate the corruption within the judiciary, to cut them off. First, restore the breathing, clear the airways.
You know, when we talk about corruption, it's always bedeviling the country, whichever way you want to look at it. So there is corruption in the judiciary. Within LSK, there is that problem as well. But then one asks the question, as there is the internal sorting out through the JSC, what role does EACC or DPP play together with all these agencies in fighting corruption?
Okay, so one of the judges that we have identified in our list is a judge who was subject to EACC investigations, and she also went to court to stop the EACC process. So the Ethics Anti-Corruption Commission is a Chapter 15 commission. What are Chapter 15 commissions? These are the constitutional commissions and independent offices that are identified in the Constitution of Kenya in Chapter 15. In Article 249 of the Constitution, which is in Chapter 15, they are meant to work independently and not subject to control, and they are meant to promote constitutionalism, etc. Even the judiciary is meant to be accountable to the Chapter 15 commissions. That includes the Ethics Anti-Corruption Commission. So if there is suspicion of corruption, EACC is entitled to investigate, whether it involves a judge, a judicial officer, a lawyer, even the president of this country, a cabinet secretary, a minister, any person, any state officer, any person in this country. If there is suspicion of corruption, in the case of EACC, they focus largely on public officers because they don't have the capacity to investigate all forms of corruption. So they focus on public officers, and then the Directorate of Criminal Investigation within the National Police Service focuses on all other forms of corruption. So these are agencies that are recognized in the Constitution to fight corruption. So even members of the judiciary have to allow themselves to be subjected to that investigation. If it is pure harassment, because sometimes the executive is used to harass the judiciary, then there will be special exceptional cases when there may be need for intervention. But you see, EACC is independent. It is not, the police service is meant to be independent, but doesn't act as independently. EACC at least is independent. So when you interfere with their investigations, and this was a very public case in which some people were caught with allegations of money changing hands, and then the investigation touched on a particular judge, was mentioned. We don't know, she's innocent until proven guilty. And she may never be proven guilty. She may be innocent. That is the law. But the point is, if you now suffocate the process of accountability and finding out, then you are sending a message to everyone that we, as judges, are above the law. We are above investigation into corruption. The moment you send that message, you increase, let me call it the courage in quotes, because it's a false courage, of other judges who may not be of great integrity. I keep insisting the majority work with a lot of integrity. But you encourage a few others to maybe consider a temptation in this kind of situations. So that's what we are saying. We need to unclog the airways. Let investigations progress. Let this organ breathe with the accountability structures in place.
So is there an understanding across board that needs to happen? Because it would appear as though the judiciary might feel otherwise by then saying that operations will continue tomorrow as normal, having taken into or not consideration what the LSK has said as of last week.
I don't know whether the judiciary could have issued a different statement. Even when Kenyans wanted to protest, the government kept insisting that everything will proceed as normal. Then on the day, the roads were obstructed. I think the judiciary probably felt they needed to issue that statement. But we are directly appealing to judges and judicial officers that we have already issued a communication to the judiciary. They need to understand the reason why we are taking this action that we are taking, and they need to respect the action we are taking. We are going to be respectful but firm. And what we have said is that if there are interim orders the lawyers will be able to appear to get a new date, but not for purpose of dealing substantively with cases. We need the judiciary to be with us on this issue, because what we are doing is for the benefit of all Kenyans. And if indeed the judiciary is serving Kenyans, as we believe they are and they should be, then they should recognize and actually appreciate our efforts to clean house, because this cleaning house has to be done. Some of the cleaning house is internal, and some of it is external. So external accountability is very important. That is what LSK is trying to achieve.
There is internal and external accountability, and I want to look at the situation where every judge is a lawyer. That means they're your members.
Yes, in
right?
a sense.
In a sense.
They are not active members.
Yes.
The moment they become judges, they stop being active members of the law society. As a general rule, they don't come for meetings. They don't vote, and if they come, they just come for CPD, for training. We meet them in bar benches, but to preserve the independence of the judiciary, the moment they are appointed as judges, it's like they cross to the other valley, the other ridge. They cross over to the other ridge.
Yeah.
But once they are judges, if they retire, judges retire at 70, judicial officers at 60. They then come back and continue to be members of the Law Society of Kenya. Now they can continue in active practice. So every judge or JO was an active LSK member and may become, after they finish their tour of duty in the judiciary, once again an active LSK member.
In one way or the other, you're still tied at the hip.
Yes.
And one looks at where now, as the Law Society of Kenya, you're looking at your former members misbehaving out there. Investigations are ongoing. And one is expected, or rather one hopes that LSK would stand and say, because of your tainted image and how you're viewed, whether you retire at that point when now you are able to practice, LSK is unable to give you a certificate to practice because you have a tainted history and you don't want to be associated with you. Are these some of the things that perhaps maybe LSK is looking at? Including also deregistering those members of yours who as well are not playing by the book.
The Council of the Law Society of Kenya, as the governance organ responsible for governing the society, is the one that considers applications for people who want to renew their practicing certificate while they have not been active for some time. And they do consider matters on a case-by-case basis. And it is actually useful to come up with internal guidelines to guide the Council of the Law Society, especially in regard to those people who have a clear and prominent kind of like a public image of corruption. However, the same constitution also talks about innocent until proven guilty, right to a fair hearing. And the Law Society as the foremost defender of the right to fair hearing under Article 50 and the right to fair administrative action under Article 47 of the Constitution. Of course, we have to extend the same grace to our own members. And that is why precisely we want to unblock those mechanisms for fair administrative action like JSC and for fair hearing like courts or the tribunals that sometimes are formed to investigate the conduct of a judge after JSC determines that a tribunal should be formed. We want to unblock them so that they happen in an environment of fairness. And then if somebody is found innocent, then the reputational harm that they have suffered is taken away. And if they are not found innocent, then they face the consequences. So that's what LSK is going to do. So to come back to your question about how we deal with either our own members or even people who are in the judiciary who then come and want to take out a practicing certificate, our role as LSK Council is first and foremost to ensure that the mechanisms for accountability are in effect, they are working, the processes are working, and then to respect the constitutional rights of our members as they are going through those processes, which means you are entitled to practice for as long as you are going through the process. But if you use certain mechanisms to then obstruct those processes of accountability, where there is a strong perception of influence, because this is your colleague in the judiciary that has given orders in your favor, then now we need to come up, speak strongly about it, so that we bring to an end that practice.
So, what do you think beyond stopping tomorrow and beyond sending a message or the appeal to say that we need to pay attention to some of these matters, that this boycott of the courts countrywide tomorrow will achieve?
It is already achieving quite a bit, even right now as we are speaking, because it is raising attention to these important matters. Tomorrow we are also going to share with the advocates a link through which they can give us feedback, including on allegations of misconduct and also performance. Performance is positive or negative. And I think when you receive feedback, it should never just appear in the negative sense. Some feedback is to compliment or to appreciate the very great work of some judges and judicial officers. For several years, I was the chair of Nairobi Legal Awards Trust, and we used to ask our advocates to give us feedback on a few judicial officers that they had identified as exceptional service. And we'd get the feedback, and based on the feedback, we'd determine who is a judge or judicial officer who's doing well, so that we could also appreciate them. So when I talk of feedback, feedback should be viewed 360 degrees. In fact, most feedback, 80% is expected to be positive or appreciative, but still, it's feedback that helps you to get better. When I used to teach in a law school, we used to get feedback from students every semester. And that feedback was very helpful. They would aggregate the feedback from the students and tell you you've scored 3 out of 5 regarding punctuality. And you could tell. The students see different lecturers coming into class. This one is punctual, they gave 5. This one, they gave 3. So it meant you needed to improve punctuality. They would assess you on things like preparedness. How have you been prepared for the class? Because the students can tell this lecturer is not even prepared. Their notes are yellowing notes that they've used for the last 4 years. They're not even aware of which was the item to be covered today. They are being reminded by the classmate. So then you get feedback. So we also want to give feedback to the judiciary. That feedback will give to both the judiciary and JSC. Once we get the feedback, this is going to be something we'll be doing regularly. Then we'll use our structures to ensure that the feedback is implemented. And where it is clear information about corruption allegations, then we'll ask JSC to process it. And the Judicial Service Commission, we have told them that they also need to build up on their investigative capacity. JSC is meant to both receive and process complaints on one hand, and on the other hand, to investigate on its own. Many times when you have complaints, the level of evidence is not high enough. But it doesn't mean JSC then says, okay,
we can't find
we can't do anything. Because they are a state organ that can have investigators, either internal, they can collaborate with other state agencies if they need to. So they need to have greater capacity, and that's also what we are telling the JSC. So we are not just saying that the challenge is at the judiciary, where there's challenge of accountability. Even JSC itself has challenges of accountability. And they have been slow in processing complaints that have come before them. Even the ones that don't have any obstruction, they've been slow in processing those complaints. So we are going to keep engaging them so that there's tangible outcome, both on issues of corruption. Sometimes it's not corruption, it's just misconduct or low performance, poor performance by some judicial officers or judges. And also, there's positive feedback. Like now, the judiciary leadership and JSC have announced that they're going to start releasing every quarter performance, individual performance, kind of like reports on each judge. This is amazing. As LSK, we support. This is positive. So when they do a good thing, we support. We work with them. And when we get those performance measures, what is our job? Our job is not just to condemn, is to help the people in the judiciary to perform better and better. Over the last few years, there's been a lot of complaints about budget in the judiciary, about number of judges and JOs. And LSK has been very much at the forefront in echoing the judges and the judiciary's concerns. What has happened is over the last 3 years or so, the budget of the judiciary has doubled. The number of judges and JOs that have been appointed has increased. So we are saying, can we now get the dividend as a people of Kenya, the justice dividend from this thing that is happening? And when we find the justice dividend is not being attained, then we have a right to blow the whistle. That's what we are doing.
I mean, briefly, because time is not on our side, one would ask the question, while we look at LSK now and the judiciary going head-to-head, there is also Kenyans as well who tomorrow will be having a difficult time. How can Kenyans as well plug into this conversation so that it's a wholesome conversation that no one is left behind?
Yeah, would like Kenyans also, through their lawyers, when they find they have specific concrete concerns with some of the things that have been happening in the judiciary, to also engage, because this is something we are doing for the benefit of the public. How can the public engage? There are various mechanisms. One, there are existing mechanisms within the judiciary and the Judicial Service Commission, where there is a clear evidence of misconduct. You can go to the Judicial Service Commission. In other cases, maybe performance issues, you go to the Judiciary Ombudsman or the Judiciary Accountability Structures. At every court station, there's a head of station, etc. You can do that. Number two, you can raise a complaint with the lawyer who is representing you, if you have any lawyer representing you. Number three, there are a few other agencies that you can use, including the Law Society of Kenya. You can approach us directly. Sometimes you can approach EACC if it is an allegation of corruption, and so on. So what we are trying to say is we want the public to walk along with us, because what we are doing as lawyers is for the sake of the public. And I also would like to say that it should not appear as if it's a confrontation between the bar and the bench. I know externally it may appear that way, but very many members of the bench actually support LSK's effort in fighting and rooting out corruption and inefficiency. The judges and JOs who are working hard and well are also very discouraged when they see what is happening by their side. They are very much happy, several of them, with what we are doing. So it's not like a confrontation of two institutions. It's just two different ways of achieving the same objective of judicial accountability. And that's why we are appealing to the judges and JOs. We are telling them, work with us. When we come to the court tomorrow and we say that we are not proceeding with matters, please respect that approach of LSK, because it is job we are doing to build the judiciary as an institution.
Indeed. He's the president of the LSK. Charles Kanjama has been with us this morning. Tomorrow's one to watch, but also beyond tomorrow, and see what it will actually then yield. Thank you for being here with us this morning. Explanatory in many ways. Asante sana.
Thank you. It's been a pleasure. Thank you for inviting me.
All right. Good morning at 9 a.m.